Look at this.
The attorney's office essentially
Cameraman.
on receiving subject of an arraignment, subject of a conference.
Okay, lunchbox.
The Commonwealth felt that it was appropriate to file this motion asking the court to simply order that the counsel conform their conduct.
Now here's David Yannetti.
As for me, Your Honor, I have 3 words for this court. 3 words forming
There we
one
go.
question.
This is where he gets mad.
How dare they? How dare the prosecution try to prohibit defense counsel from doing our jobs? How dare they ask this court to take away our First Amendment right to free speech? How dare they try to trample on my client's Sixth Amendment right to a fair trial and their 14th Amendment rights to due process of law? How dare they? Your Honor, I've represented Karen Reed since January 29th of 2022. From the beginning, she has faced a prosecution team that did everything they could to poison the well of public opinion. Before she was initially arrested on manslaughter charges, I formally contacted the Massachusetts State Police in writing and promised that if they took out charges against her, my client would fully cooperate. I confirmed that I would walk her in and surrender her.
Doctor needed the perp walk.
Completely ignored that promise of cooperation. Insisted on arresting her so that they could parade her before the media.
Proctor did that, by the way.
They got their perp walk.
They got the perp walk.
Of the well began.
Exactly.
And almost immediately thereafter, no less than Superintendent-in-Chief of the Boston Police Department, Gregory Long, came out immediately in public to declare that the state police and the Norfolk DA's office had arrested the person responsible for John's death.
Person responsible.
Superintendent Long did not caution that someone accused of a crime is innocent until proven guilty. He did not caution the public to keep an open mind.
Nope.
He did just the opposite. He announced in public for everyone to hear that in his opinion, Karen Reed was guilty and let's pat the prosecution on the back. That statement was broadcast on almost every media outlet. It was posted to the Boston Police official Facebook account. It was posted to the Boston Police official Twitter account. It was posted to the Boston Police.
They're all concerned about poisoning a jury pool.
Right from the start, the Boston Police announced that Karen.
But only when the defense fights back. Now when their side gets shit out there and leaks. Yeah, where was Lally then?
From the start, they controlled the narrative, and as long as they did, all was well. They had Karen Reed right where they wanted her, and with the public being told, there's nothing to see here. She hit him with her car. She's guilty. Just trust us. And they were able to control the narrative and get away with it, I suggest to the court, because they withheld discovery from us for months. At my client's arraignment in Stoughton District Court, you can pull the tape. I couldn't even get a police report from the government.
Wow.
They claimed that no police reports had been written. They fought me.
When was that?
I was right at her arraignment in Stoughton District Court. They fought me when I tried to get search warrant affidavits. They stalled and delayed and hindered our ability to fight the narrative that they had put out there. And in the meantime, Canton Police Chief 𝗵𝗵𝗆 was allowed to publicly state that the facts revealed by the defense were just, quote, sensational accounts. And they really should just trust.
Nice going, Helena.
Was allowed to publicly state that the defense attorneys were just spinning it and it's going nowhere. The Norfolk County DA is allowed to suggest regarding the timing of Jen McCabe's 2:27 a.m. Google search, which we can't prove without any doubt. The Norfolk County DA suggested to the media that we may not have interpreted the raw data.
Yeah, remember that when they're like, oh,
both Chief 𝗵𝗵𝗆 and the Norfolk DA.
Yeah, that Google search, nothing to see here. You're just interpreting it wrongly. They still haven't explained how we're interpreting that wrongly, but they get to talk to the media. It's okay when they talk to the media. Okay.
Spokesman David 𝗏𝗏 claimed that they were ethically constrained from commenting, but that didn't stop them from commenting anyway, publicly stating essentially that the defense is not to be trusted. Where was the prosecution when all of that was going on? Where was the request for a gag order then? It's a rhetorical question, of course, because there were none. The prosecution was perfectly happy to have potential jurors hear all of this unfairly prejudicial information about Karen Reed because it would help their pathetically weak case that they brought against her. And the case is pathetically weak because they've arrested the wrong person, yet inexplicably they refused to admit it. They were quite happy with the press this case was getting when it was in their favor, and their minions were out doing their work with the media. Once the evidence started to trickle in, the tide turned, and it did turn in a big way. In May of this year, Your Honor, we displayed the injuries to John O'Keefe's arm, I should say. And they started to question, hey, what really happened here? That was a seminal moment when everyone started to realize Karen Reed did not do this, but somebody else did. And it is also salient that our statements were made in court. In court. Their statements were made out of court. Can you imagine the hypocrisy of the prosecution now coming before this court to suggest that a gag order is appropriate? Dare they?
How dare they? How dare they? How dare they?
It's unconstitutional.